projects to address these challenges. The Holidays Act. This year, reforming the Holidays Act remains one of my biggest priorities, and I intend to introduce a bill later this year. We have invested time wisely to consult with technical experts, employers, and workers on an exposure draft bill. Feedback is clear that fundamental change is needed to provide the simplicity and certainty that employers and employees need. To replace the complex current arrangements, I intend to introduce an hours-based accrual model for annual leave and sick leave, and an expanded version of pay-as-you-go so that everyone can benefit from flexible working arrangements. This year, I expect to progress changes to legislation to deliver on the commitment in the ACT National Coalition Agreement to reform health and safety laws and regulations. I believe that we can keep workers safe from harm without stifling economic growth by bogging down businesses with complex or confusing rules and regulations. I've heard from businesses, workers, and employers across the country that we can do better, and we will. I recently announced a suite of changes to the Work Health and Safety system. This includes improvements to the Health and Safety at Work Act to focus the system on critical risks and cutting compliance costs for businesses, especially small, low-risk businesses. I'm also making a range of legislative and operational changes to improve business certainty and public confidence in WorkSafe. In the coming months, I intend to seek Cabinet agreement to a sector regulatory relief package to address sector-specific pain points in the system. I have also introduced an Employment Relations Amendment Bill, which aims to improve a variety of employment settings. The bill includes a gateway test to provide certainty and clarity when it is unclear whether a person is an employee or a contractor. Contractors play an important role in New Zealand's economy and society, and I believe these changes could improve conditions for some contractors, reduce risk for firms, and help ensure businesses compete on quality, price, and productivity. The bill will cut red tape at the start of employment by removing the 30-day rule. Currently, individual employment agreements must reflect the terms of an available collective agreement for the first 30 days of employment. The rule is convoluted and confusing, and the process adds another administrative cost on top of many others, and those costs are dragging down workplace productivity. Removing the 30-day rule will ensure employees and employers can be free to agree on a wider range of employment terms from day one of employment. The bill also proposes changes to simplify personal grievances. Employees who earn over $180,000 per annum will be unable to raise an unjustified dismissal personal grievance, an unjustified disadvantage personal grievance, where it relates to dismissal, unless unjustified dismissal protection is negotiated as part of their employment agreement. There will also be more consideration given to an employee's behaviour in the personal grievance process. Certain remedies will be restricted when the employee's behaviour has contributed to the issue and removed entirely if their behaviour amounts to serious misconduct. I also want to touch on the reforms to pay equity this government passed earlier in the year. I acknowledge these reforms have been contentious, but I want to reiterate that the purpose of the reforms is to ensure that a path for addressing genuine sex-based undervaluation remains in place. Reform was needed because the pay equity regime had become untargeted and unaffordable substitute for usual wage bargaining process. Pay equity remains, equal pay remains, and no one has had their pay cut. The government has also reinstated the ability to deduct pay in response to partial strikes. This is a vital step in rebalancing the rights and consequences of industrial action. Partial strikes are industrial actions that normally involve turning up to work but refusing to partake in key parts of the job. Often it is the public who is losing out or is caught in the middle when the partial strikes occur. Intentionally causing disruption to customers or to the employer's output is not only currently a permitted collective bargaining tactic, but employers' options to respond are limited. Currently, if an employee is engaged in a partial strike, their employer cannot deduct their pay unless they suspend the employee or issue a lockout notice. I've heard of patients facing delays in receiving medical treatment due to increased wait lists, kids missing out on education while their teachers take to the streets, and honest, hardworking New Zealanders left stranded at train and bus stations as drivers and operators abandon their duties. While I recognise that employees are intended to strike, this disruption to public and customer service does need to be balanced with consequences for those who withhold their labour. Now, I know there's a lot more that's in our portfolio as well, but I'm happy to take questions on those topics.
Thank you, Minister. I've got a primary from the Honourable Jan Tinetti.
Great, thank you. Thank you, Minister. I'll start with pay equity, and I'm signalling that I've got questions around pay equity and then later on questions around health and safety, the areas that I want to focus in on. So with pay equity, I'm really wanting to look forward to what, where we're going with pay equity, but I just want to ask a question going back to look forward, if that makes sense, because I don't think that we can understand where we're heading until I actually know how many of those 33 cancelled claims were at milestone 5, which means the contingency had been put aside. There had been an understanding that, or an agreement that there was sex discrimination or undervaluation due to sex discrimination. So the contingency had been put aside, and they're probably within 6 months of being settled if they'd got to that stage. So I want to know how many of those 33 claims were at that stage.
Oh, I thank the member for the question. I'm not the member responsible for any of the individual claims, and so I cannot answer that question.
So on that then, if you're not in that, when you were coming to make that decision around the changing of the legislation, would that not have informed you around the process that had happened so far? Would that not have been information that you would have had to have been put in front of you to help you make that decision?
The government did not make changes to the pay equity regime in response to any individual claims. We did it because we wanted the claims process to be more robust.
Okay.
So just to confirm, the contingency doesn't sit within your vote, correct?
That's correct.
Yeah.
No, but
So-
what I'm trying to get at there, Mr. Chair, and I appreciate that, but what I'm trying to get at is if you're making changes to the legislation which does sit within the vote of the Minister, then that information would inform those changes. So that would be information that would have had to come across, in my opinion, to the Minister, but the Minister says she doesn't know that, so she wouldn't have had that to make that information, to make that decision.
So happy to take questions. I'll come to you. I've got a sup from Parmjit Palmer, and then I'll come to your primary. Just in terms of the pay.
Oh, no, I want to stop on this.
Oh, you're a sup. Okay, I'll come to you after Parmjit then as well. Jan, I'll give you an opportunity to ask another supplementary on this if you can bring it in relation to that.
I'm happy with that.
Happy with that? Okay, cool. Parmjit?
Thank you, Mr. Chair. Minister, you used the word untargeted when you were talking about pay equity. Can you elaborate on that? Like they were becoming untargeted?
Sorry, Parmjit, we can't hear you.
Oh, okay. Yep. So repeat my question. So my question is about the term that the minister used, untargeted, that pay equity claims were becoming untargeted, and wanting to ask the minister to elaborate on that.
Yeah, thank you. So in many ways, the claim process that we have put in place through this government is reverting to a lot of the claims process from the 2017 bill that was originally proposed. But also, if you look at some of the claims that had progressed under the Labour Party claims process, there were claims that had up to 90 different occupations within one claim that went as far as hospital-based dental workers, people who were cultural advisors, wheelchair technicians, all within one particular claim. There were also, I think that the need to address the fact that, on some of those claims, they had review provisions that allowed for non-sex-based discrimination factors to be considered, things like inflation, which I don't believe goes to the heart of the sex-based discrimination at the core of the Act.
Thank you.
Thank you. Tiana.
Thank you. I was just supplementary to what Honourable Jan Tinetti was saying around pay equity claims, and I do get your point that it's not within your vote, but I do think that there is a duty of care that exists for the government to actually really understand what was happening right across those 33 claims. And just for the minister's information, I did put parliamentary written questions to 14 ministers who had portfolio coverage for those 33 claims. None of them knew what was happening until you made until you guys had that meeting in cabinet. So what that points to me was that there was a missing gap in terms of your process. So it's all very good and well to say, well, actually, it doesn't fall within my vote. Well, then, if no one's looking at it and looking at the actual individual impacts across those 33 claims, then where does the responsibility sit? Comments.
Well, look, I think it's really important to note that the government, and I've said this throughout the entire debate today, when we did the annual reviews, when we were doing the committee of the whole house process, that the government did not pass changes to pay equity because of any particular claim. We did it to improve the robustness of the system in general.
But my question is to the duty of care of people in those 33 claims. And if the responsibility doesn't sit with you or the 14 other ministers that have portfolio coverage, where does it sit in your government?
So if you would like to address questions that are specific to a specific claim within one particular agency, you should address those questions to the minister responsible.
I did. I put parliamentary written questions and there was no.
Thank you, Tiana. I'm going to allow Jan Tinetti a final question on this, and then I think we're going to move on because it's not actually directly related to this estimate. So, Jan?
So, Minister, you said around the fact that you changed because there were something like 90 claims, or so, I'm not sure what the actual figure was, but within one claim, 90 sectors within one claim. So, presumably the change meant going forward from what you put through and the work that you did, you would know that many of those would not be able to progress under the new legislation. So what advice did you seek, or did you seek advice on which pay equity claims would not be able to progress under the new rules?
I didn't seek to understand how any specific claim that was currently under the process would be affected, because I was not doing this for any particular claim. I am doing this to make the system more robust in general. And if you think of, some of the issues that we had, the pay equity process was not necessarily focusing on addressing sex-based discrimination, but was also picking up non-sex-based factors. And if we truly care about stamping out sex-based discrimination, our laws should do what they say they do.
Is that good lawmaking, though, if you're not understanding the full ramifications of what your decisions are? Is that good lawmaking?
Thank you. I've already said that was the last question before, unless the minister wants to answer, and then we'll move on.
No, I just want to make one really clear statement, which I made in the House a few weeks ago, which is I'm not a lawyer here to present in favour or against any particular union claim, or in favour or against any particular employer when they're going through a claims process. That would be improper. And so many of the questions that I have had asked to me would actually be improper to answer, because that could get in the way of any particular claim that could in the future be brought. But that's information that I do not have on hand. However, I have mentioned many times, we are not doing this for any particular claim. We're doing this for the robustness of the system. And if you look at where our system has ended up, it is still actually a very liberal system internationally. In the UK, for example, you cannot take a claim outside of your employer. We are allowing people to have comparators even outside their employer. So our system is still quite liberal.
Right, thank you. Vanessa Wienik.
Thank you, Mr. Chair. Thank you, Minister. I'm wondering if you could please update us a bit on the Labour Inspectorate's performance, especially when it comes to questions and investigations around exploitation of migrant workers. It's a kind of a topic that the school are very interested in.
Yeah, absolutely. Look, I have a lot of faith in our Labour Inspectorate. I think they do a lot of really good work. At the moment, I know that we have around 85 Labour inspectors, and they're going out into our community every day to ensure that minimum wage and minimum labour standards are upheld, whether that's for New Zealanders who have been here for generations or people who have recently migrated to New Zealand. I've brought Suzanne from the Labour Inspectorate here to talk through some of the numbers, but I think it's fair to say that the number of cases that they're dealing with is high, but we also have fantastic targets that they meet every day.
Yes, thank you very much, Minister. In terms of the Labour Inspectorate, we are well exceeding our estimates targets of 2,200 interventions. We're well over the 3,500.
Sorry, Susan, you just pulled the
Sorry.
mic on board. Thank you.
It's the first time I've ever been told I'm quiet. I'll speak up. You're right. I'm really proud of what the Labour Inspector has done. So our estimates are just over 2,000. That's what we're interventions.
Sorry, can you speak more slowly and clearly?
Absolutely. So our estimate targets are just over 2,200 interventions for the Labour Inspectorate. However, this year already, we're at 3,500 interventions by the Labour Inspectorate. We have 85 Labour inspectors. Of that, we've also increased our interventions or our activities within the RSE scheme by 33% this year with the same people. And
Sorry, that's an increase in what, 33%?
33% in intervention. So when we're working with RSE employers and with employees, what you've also seen is that as well as increasing numbers of activities, we've increased how quickly that we complete our investigations. So more than 91% of our investigations are completed within 12 months now where we start. But we take a very balanced approach. In terms of our compliance activity, we will always do information and education and guidance to employers, and we will relieve the detailed enforcement activities such as infringements and prosecutions through the ERA for those serious offenders. So it's a very balance between enablement and enforcement approach that the Labour Inspectorate takes.
Thank you.
Just a supplementary question on that. Oh, sorry.
Oh, I was just going to add, the committee will remember perhaps at our last hearing with the department that we had brought together a range of compliance activities across MB, and that has given us a better outcome, not just with the Labour Inspectorate, but I think the member also asked about migrant exploitation, and migrant exploitation is also reduced significantly in the last year.
Yeah, so that was going to be my supplementary question, was has the evidence sort of shown that there is a reduction or a change, and any other feedback from the people on the front line?
So we have seen a significant reduction in the number of migrant exploitation reports, down about 33%. But I also wanted to reassure the committee that we take those reports exceptionally seriously. They're not all about employment standards. They can be about a number of other things that people will come to us. But we triage, so in other words, we respond to those requests and reports of migrant exploitation with 97% of those responded to within 5 days.
Wow,
Well done.
impressive.
I think that shows
supplementary
fantastic
from
work.
Jan Tinetti.
So, Minister, as a supplementary to that, you know, you've talked about, and we all know that there's a significant level of death and serious workplace injury. I wonder if you know of how many of those workplaces where that has happened in the last year were inspected in the year prior to that happening?
On hand, I don't have that specific information, but we could potentially get someone from the health and safety or work safety team.
We are going to be seeing them 15 minutes afterwards. So
Okay, they don't
maybe
have it either.
we'll be seeing them afterwards anyway.
Okay.
So
So we'll either ask that
That we'll
after
put it in
or
writing.
we'll put it in
Yeah.
writing.
Yeah.
Great.
That would be a good idea.
Okay. Jan, we can move on to your primary.
okay, thank you. Minister, you have announced in 2 stages changes to health and safety. You made an announcement in March and one recently. Why did you make them in 2 different stages?
So we have multiple stages of announcements coming
I'm
with
talking
health
about
and
the one in
safety.
March and this one recently.
Yes, and I've got more to come, which is what I'm alluding to. My work does not end, Jan. I've still got more. We have multi-stages for the health and safety because it is such a large tranche of work. And rather than waiting until cabinet decisions are made on every single element that goes through cabinet or every letter of expectation I send and waiting right until the end, I think it is important to allow people to know where the direction of travel is going as we make those decisions. So there have been various announcements. The ones that we have made to date are quite broad, but focus mainly on refocusing the entire health and safety system to reduce critical risks and reduce harm to workers. And that's really important. The whole focus of why we are doing this reform is we do actually want workers to come back safely every day to their families. I think it's quite heartbreaking when people don't return home, and we do want people to be safe. But on top of that, when we were going out around the country, hearing from business owners, managers, and workers on the ground, which I think was really important, and I did consultation very differently to how government does. I went to hear from the people directly. They said that they had a lot of big concerns about the cost of compliance and whether or not that cost to comply is actually seeing a reduction in harm, and a fear from WorkSafe that, and in some cases, I even had comments that people had more fear of WorkSafe than the police are turning up, and having such strong fear of the regulator rather than feeling that the regulator was there to help, I don't believe is conducive to a good health and safety system. So we are refocusing the system on providing more guidance upfront to businesses so that they have a positive relationship with WorkSafe. They understand what the rules are, what they need to do to comply and to reduce risks to serious injury and death in their workplaces, but also that everybody is aware that they don't need to be sweating the small stuff with small-scale paperwork compliance, but really focusing on targeting those critical risks that would be found in their workplace so that there is a prioritization going on from the worker, the business, and WorkSafe, that we care about deaths and serious injuries. We don't care about just making sure you've got a paperwork in the filing cabinet.
Okay, can I ask something? Thank you. So the Ministry for Regulation's feedback on your original cabinet paper has criticised the process of it coming out into tranches because they've said that one is reliant on the other, and this you're not able to, from what I can see here in their feedback, they're saying that there was sort of a lack of understanding of how that would interact in that because you haven't put them out together. But also exactly what you've just said around that low level, they've criticised the fact that there's been that emphasis on the low level risk compliance, health and safety compliance. And they say this assumes that time spent on low value health and safety compliance activity will instead be spent on higher value health and safety activity. But isn't it just as likely that the time and resources will go to non-health and safety activities? For example, activities that grow market share and earn revenue rather than on health and safety. So what evidence do you have, given that the Ministry of Regulations has said that, what evidence do you have that that time taken away from the low value health and safety would be spent in other areas in the health and safety?
Well, it's not necessarily about the time spent on compliance activity, Jan. What we're trying to do is reduce compliance burden to businesses in general. Time spent on compliance for compliance sake, I'm sure everybody in this room would agree, is not worth it if it's not actually seeing results. So if people are reducing time based on compliance, that's a good thing. If we're focusing on those critical risks, and that's the aim of this entire reform, we want people to focus on those critical risks. But if that comes at a reduction in time spent on those activities, then I would suggest that that's a good thing.
Tiana.
Yeah, just to sup on this, can the Minister give us their working definition on what critical risk is, and in her answer, if you could give the parameters of that. So your widest parameters of what would include critical risk, right down to your narrower definition. And after you answer that, if you could also answer me whether you would include musculoskeletal harm within critical risk, and if not, why not? And also mental harm. And the reasons why I ask that is there are significant harms that are caused because of musculoskeletal harm, back issues, spinal injuries, that kind of thing as well. And we know that mental health is a really, really big issue. So again, my question is around your working definition for critical risk, from your widest parameters of what you're considering right down to the narrowest parameters of what you are considering, and then also whether musculoskeletal harm is possibly going to be included in that, and mental harm.
Well, thank you for the question. The focus is about critical risks, like you rightly pointed out. At the moment, we are defining critical risks as those that cause death or serious injury or illness, but the specific details of what that involves is still to come. To Jan's point, still got a lot of announcements to come.
So on top of that, because we know that there is sometimes mental harm can move on to self-harm and also onto suicide. So is that possibly in the mix in terms of your definition for critical risk?
Look, I'm not going to be making an announcement today. I totally understand where your concern is coming from. However, you'll simply have to wait for.
I want to know whether it's actually in the mix in terms of the things that you're thinking about, or whether it's off the table or not. People want to know.
We will be making an announcement on the definitions of critical risk at a later date.
Okay, Parmjit.
So, Minister, it's a sub to the question you had before. So, correlation of time spent on compliance versus safety achieved. Is it something, Minister, that you have mentioned compliance cost and productivity, these terms? Is it something wrong if somebody is able to comply with what is needed by and also keeping the cost down and is able to achieve productivity or able to increase productivity? Is something wrong with that?
Oh, I think that's perfect. That's exactly what people should be doing under our system. You can have a highly functioning workplace, a high productivity workplace, while also focusing on keeping your workers safe from harm. And I'd make the point that with a lot of business owners that I've met over the last year and a half with this work program, they don't want to hurt their staff. They know that hurting staff is dreadful for their business and for productivity. And it's in everybody's interest that their workers are safe and coming to work, being able to be highly productive, going back to their families. Having workers injured is nobody's goal, and it's certainly not this government or business's goal. So it is possible to have a highly productive workplace while focusing on reducing worker harm. But where we have compliance for compliance sake, that does lead to unproductivity. It does lead to costs, time, resource, admin, HR. And I'll just give you one example. When I was doing the roadshow, I went to an industrial area of Auckland and talked to a woman there. And she said every month they have to go around their work site and ask people, have you had a paper cut? Have you had a staple incident? We need something to put in writing because our bosses are asking for us to get the paperwork to show that we're complying with the Health and Safety at Work Act. That's really unproductive work. That's not actually keeping anybody any safer. It's compliance for compliance sake to tick the boxes. And that's what this government is moving away from. Too much compliance, too much red tape, too much box ticking exercises. That's not leading to safety outcomes.
Cool.
Thank you.
Parmjit, you had you find that? Okay. Jan? And then
Great, thank you. So I've got a sub to what Tiano asked. It's probably, I'm going to wrap it into, there might be two. And I'm not sure that I heard an answer from you if you consider musculoskeletal harm a critical risk. I don't think that came through. So I'm really keen to follow up on that. And then what work is planned or underway at WorkSafe on musculoskeletal risk harm, given that WorkSafe's own research suggests it's the source of the most harm in New Zealand workplaces?
So I did address that question. I said we're not making an announcement today on what would be considered a critical risk. So I did address the question, Jan. To the second question, that would be a question for WorkSafe, which may be better addressed in your next session with WorkSafe, although I am happy to bring them up if that's how you'd like to use your time.
No, I just want to have a follow-up then with that, if that's okay, Mr. Chair. From reading your cabinet paper, that's what the issue is at the moment, is that people are getting confused around this, knowing that it is causing the most harm in the country, in the WorkSafe. It is the source of the most harm in the New Zealand workplace. But reading your cabinet paper, it doesn't seem to meet that definition of critical risk. And I really want to get your, like you may say you've addressed the question, but people reading that cabinet paper are concerned around the fact that it doesn't seem to meet that threshold of that critical risk. So we want to sort of get some understanding of you and I guess assurance today that you're taking this very seriously.
Okay, I do take health and safety very seriously, which is why we're doing the entire reform. But like I said before, I'm not making an announcement in the committee today. You'll have to wait for that. I know you can't have it both ways. Either you want all of the work to happen extremely fast, or you allow for people to have cabinet processes that take time and allow people to have information in the public domain.
Yes, we want assurance that you're over it, Minister, and you're not giving us that assurance.
I'm not going to make announcements because you asked me a question, Jan.
Okay.
We have to wait for good process.
I've got a sup from Grant, a sup from Tiana, and then we'll move on to Grant's primary.
Yeah, thank you, Sophia. So just as you were, Minister, as you were moving around the country and interacting with employers, and so did any of them ever express any concerns for their own health and safety in terms of the stress and worry that came through from from the Health and Safety Act as it stood and the excessive paperwork? Did any of them express those sorts of concerns to you?
Oh yeah, I mean there were a lot of business owners who were highly stressed.
Yeah.
And a lot of that was to do with the fact that most people in business want to do the right thing. But if you're already a small business owner dealing with things like Holidays Act compliance, trying to get customers and make sure that you've got cash flow and revenue, and you're dealing with the health and safety system, you are already time poor, and you don't have a lot of money just sloshing around to pay a consultant to get those answers. And so trying to simplify the system, provide more guidance up front issued by WorkSafe to those small businesses will give people a feeling of confidence that they are doing the right thing by their employees, but they will also be able to go to bed at night with less stress, knowing that they're less likely to cause harm to their workers in the first place. And I think that's at the heart of this reform. We are a small business economy. We do know that people are trying to do the right thing, but it is very hard out there in the economy at the moment, and it's very stressful. So if we can reduce stress while also reducing harm to workers, then we're on to a winner.
Thank you. Tiana.
Yeah, thank you, Mr. Chair. My question is around, because I did hear your answer that you've been going around the country and talking to folks and also to employers and also to workers. And so my question is, will she commit to meeting regularly with the CTU? I know that you had met with them once, from what I could tell, and I did put into a parliamentary written question whether you would commit to doing that. And the answer I got back was you hadn't had anything put in regularly. So my question is, if you're going to talk about making sure that you talk to people, it makes sense to have a regular time where you meet with the CTU to discuss the issues that impact their members. So I'd like an answer to that.
Oh, well, thank you very much for the question. Look, I don't meet regularly with the CTU because I don't meet regularly with any advocacy group. I have had 4 engagements with the CTU, and I have had engagements specifically on health and safety with the CTU. One of the reasons why we have the reform ending up with changes to the Health and Safety at Work Act rather than a repeal and complete replacement is actually because I listened to the CTU. They, as well as Business New Zealand, did not wish to have a complete repeal and replacement. So we have listened, and I have had engagements with the CT.
So when's your next meeting with them? When's your next meeting with them?
Having
Okay,
regular meetings for the sake of having a meeting. I want my meetings to be highly productive.
thank
Right.
you. We'll move on to a primary from Grant McCullum.
Thank you, Mr. Chair. You mentioned in your introductory remarks about the Holidays Act reform, and we've raised it before with you. And would you care to elaborate on how that's progressing and why it's so important for the sector and for all employees and employers?
So the Holidays Act is one of my main priorities because I've heard from so many people that non-compliance is really high and it's very hard to get it right. I mean, even MB, who's sitting with us, has had non-compliance in the past. And so if our government department's struggling to understand the laws, then our small businesses, even our large businesses too, will be finding that really difficult. But on top of that, if you think of a worker who doesn't have the resources of an HR department or a payroll system, it's got to be even harder for them to know whether or not they're getting paid correctly. And I think that's wrong. So I would like to simplify the system so any business, any government agency and any worker can understand what they're supposed to be entitled to and be paid every week or fortnight. Now, where we ended up was last year I went out for a consultation on a bill that had been developed by Labor or by the Labor government. The feedback that I received was, don't go ahead with this one because it could be even more technical and difficult to get right than the law that we currently got. So I decided to start again. And in starting again, we have now spent about 6 months working behind the scenes with my officials, and I really thank them for their work because it's very technical work, on a simplified model that at the heart has an accrual system. So if you look at the status quo, people are entitled to 4 weeks of annual leave after 12 months. In practice, we know that that hasn't been happening. People have been trying to use an accrual model in practice anyway. So we're saying from day dot, as soon as you start, you accrue leave for every hour that you work from the start of your employment agreement. By and large, the feedback I've had is that would be the most simple model, and they would like us to continue with this. We have done now, I'd say 98% of that technical work, and I still aim to have a bill to introduce by the end of this year. However, there's not much more I can give an update on at this stage, other than that we've been working behind the scenes with small and large business and payroll to ensure that's right. And at the heart of that is the implementation by payroll becomes really important. And when I first came into this role, the payroll practitioners said that they had not been consulted during the drafting of that previous bill, which is why it was so technical. It wasn't going to be easy to implement. It needs to work for payroll too.
Thank you.
Parmjit Palmer.
Thank you, Minister. Further to that, you also are working on how leave entitlement is calculated for part-time workers. So can you please elaborate on that? Where did that idea came from and how is it going to be fair for the employers and employees?
Yes, thanks for the question. So one area that our government is progressing with is the idea of pro rata sick leave, which means to say that a full-time employee is entitled to a full entitlement for sick leave. That's 10 days or an equivalent under our system. Whereas a part-time worker would be entitled to a proportion of that. In part, this is supported by business because business are the ones having to stomach the cost. They're the ones having to pay for it. And if you think of a case of, a small retail shop, for example, might have a range of part-time workers. It's a lot of liability to have on their books, to have multiple part-time employees with the sick leave at the same proportion as full-time employees. So we're looking at making it more proportional and much fairer for the system.
Thank you. Sup from Jantinetti.
Yeah, just to sup on that, Minister, I've heard your arguments around that, and there's scenarios that I'm really concerned about in this situation. And I want to put a scenario to you and get your comment on it. So if you're in a school, for example, and you've got teacher aides who all work part-time and most of them work 25 hours a week, but their working day is 5 hours, why should they get less sick leave than their colleagues who work 8-hour working days. So they don't get flu for 50% of the time. So it's concerning that there's this lump in part-time workers saying that, you know, it's not fair, but they're working the same number of days.
So if I can give you possibly the most simple example would be if you have somebody who works a 5-day week and they get ill, they could potentially take 2 weeks off, right? Because they get 10 days sick leave. If you have someone who works maybe 1 day each week, which would be, say it's every Monday, if they had 10 days sick leave, they could in theory take 10 weeks off. Those are disproportionate. And so what we're bringing to the system is proportionality. If someone is only working half the week, they should only be entitled to half the amount of sick leave, because for the other portion of the week that they might be sick, they weren't working. And so the business owner shouldn't necessarily be liable for sick leave when that person wasn't working that period of time anyway.
So in how many of those cases that you've just said there are those people taking all of that time?
I don't have statistics for
So then what's the
public
problem?
sector in that respect, but it's about what's right, Jan. We're doing this because we believe it's right.
But it's not based
It's
on
about-
evidence.
But it's about the proportion of time
But
that
it's not
someone
based
is
on
actually
evidence.
working, because time and time
Okay.
again, we put costs onto business all the time. Think of
And it's
all
not
of the
evidence.
compliance that we have.
Doesn't
This is
cost.
So
about
I'm
what's
gonna-
right in the system.
Yeah.
I don't think there are many people actually out there when I've
You've
talked to
got no
people
example.
So can I,
that don't understand that prorated sick
think
leave is
Tiana
the right
has-
thing to do.
so can I ask a
Got no examples.
Can I ask us up, just so I'm 100% clear on this? And so my wife, she works 3 days a week. And when she started her job, having up until this time only ever worked overseas, was quite surprised that even though she works 3 days a week, she was entitled to have the 10 days that her colleagues who work full-time get. So she's been able to utilise 10 days of sick leave, but only working 3 days a week. So what you're suggesting is that on a proportionality basis, she would essentially get 6 days of leave, there or thereabouts, sick leave. And therefore, if she was sick over a 2-week period, she would still get the 2 weeks off that she would normally work, but she wouldn't get 3 and a bit weeks, unlike her colleagues who are working full-time. Have I got it?
That's right.
Yeah.
It's about proportionality, and you've got it in one.
Yeah, I think that
No
she would
evidence.
think that that makes a lot of sense. Parmjit.
So further to that, Minister,
And then
given the
Tiana.
feedback that you received from businesses about this issue, that is a kind of qualitative evidence, that is kind of a survey that you did yourself. So how prominent was this issue when you were discussing with businesses and different organizations about this issue?
Oh, it's something that businesses want. It makes sense and it's clearer, because if you take that point, this is about costs to business and the balance of getting that fairness right in the system between an entitlement to sick leave for employees versus the cost to a business for the time that someone may actually be working versus how much they can take off. But it's also fairness for other employees. You know, if you've got somebody who is working a full week but gets the same time off for sick leave that someone is working part-time, I'd say that there are a lot of employees out there who never knew that their part-time workers were entitled to that and don't think it's fair that the entitlement is the same.
Okay, I'm going to take a final sup for Tano and then we're going to move on.
Actually, mine was a primary, but I can take us up if we
Oh,
get a
happy, or I'll give you the primary and then Jan can have hers after. I'm sure
Well,
she's.
that's fine.
Yeah, fire away, Tana.
Yeah, my primary is around you're putting forward like a myriad of different changes, a lot. And so what I want to know is the work that you're doing to actually monitor the impact of these changes that you're putting in. Because when I talk to workers, some of them are, I'll be honest with you, getting fed up and they're thinking about leaving the country. And so what work are you doing to measure the impact of all of these different changes, from your changes in health and safety to the pastoral strikes, to so on and so forth, on the workforce. And if you could actually talk to that work in particular, how it actually impacts workers. So we hear a lot from the minister in terms of the impact on business and compliance and so on and so forth. But what about the workers? So if the minister could answer that, I would be grateful.
Oh, thank you for the question. Look, at the heart of a lot of the reforms that I'm doing, it's about building business confidence so that businesses have a greater confidence to hire more employees with higher wages and with better jobs. That's why we're doing a lot of our reforms, because we do want to boost our economy, and that in part flows into workers, where workers have more jobs, they have more opportunities. And one of the ways that we can, over time, measure the outcome of these reforms is whether business confidence is leading to more employment opportunities around the country, and whether or not people have more jobs to go to. The other way that we can measure some of these reforms is actually through WorkSafe's own data that they will keep collecting. And I'm sure you're able to touch on that at a later point with WorkSafe, but they do collect statistics on their prosecutions, on their guidance, how many inspector visits and things that they do. We could potentially use ACC data in the future as well. But by and large, my reforms are to boost business confidence. And so I'd hope to look at business confidence statistics as well. But because business confidence will lead to better outcomes for workers and more job opportunities.
There's an assumption, but my question was around the work that you actually got and trained. You've got a whole lot of stuff, a whole lot of balls up in the air. What are you doing to actually monitor and analyze whether the impacts that are happening? And I didn't hear in your answer anything around the particular impacts on workers themselves. What are you going to do to stop workers from sort of just jumping on a plane and going over to Australia or wherever else where they get better work conditions? Those are the sorts of impacts that I think it's fair to have an expectation that will be measured by you in your office. If you could elaborate on that, that would be good.
I think those things are kind of all tied in together. Like you're talking about people getting on a plane and going overseas. There's so many other factors across government that feed into it.
Yeah, and I want to know what your work program is to measure that.
What's the work program?
Can we let the minister finish, please, Tiana?
Yeah, like if someone doesn't feel like they have the opportunity to buy a home in New Zealand, or they feel they're unsafe on the streets, or they feel like their job opportunities are not wide enough, there are many factors that could fit into someone leaving New Zealand. I don't want people to leave New Zealand. I love this country, and I want people from my generation to stay here. And it's just frustrating to me that younger people do not feel in some ways that they have as many opportunities as older generations. And I want my friends to come home so that they can contribute to our economy and raise their children in New Zealand. But if I look at some of the things that are happening across government, I think we are going to see that flow through to people wanting to stay here. But we have to get those settings right. And those settings do take time. People are still feeling the effect of the last government. They don't feel as safe, but we're seeing safety improve. We're seeing some of the changes to the Resource Management Act and changes to house prices, and those things will improve as well. But it is relevant to the question. And with the labour market settings that I am underpinning to make more flexible labour markets, we will see greater job opportunities for Kiwis. And if you think of some of the things like the personal grievance settings, if we make it easier for businesses to be able to hire and fire, there are far more job opportunities for young New Zealanders, so they don't feel like they need to leave New Zealand.
Thank you. Tiana, have you got another sup, or are you done on that?
Well, I did want to hear about what actual work is in place to actually measure this stuff, and I didn't hear anything on that.
Okay, so I'll take that as a comment.
Just to add to it, so we as at MB, we will have program of looking at the data and the evidence over time. One of the difficulties in this area, which has already been alluded to, is that in some parts of the portfolio, there's very strong administrative data, like in WorkSafe and the Labour Inspectorate. On the general labour market, there isn't, because we don't automatically collect data on people's pay and conditions as a matter of course. So some of those areas are much harder to evidence and evaluate over time. And we will periodically do an economic impact analysis of something where they try and look at some of the more macro indicators, but it is harder to measure. But that is something that is on to MB to be thinking about. What's our program of evidence and evaluation over time?
Thank you. Jan Tinetti.
So just on that and following on from that, and it's for you, Minister, I have a list of 15 areas that have majorly impacted on workers since you've come in and have had a negative impact on workers. And then there are currently, I've got, I think, 5 that are currently in process at the moment that you are working, as Tiano said, balls in the air. Is there anything that happened in those first 15 that is influencing the work that you're doing in that 5? What's the evidence that you are gathering to help you with your decision making in those 5 things that you've got in the air at the moment?
Well, Jan, I'm not a mind reader. I have no idea what's in
So
the
health
top
and
15.
safety, for example, you have, let's see, well, no, you've scrapped fair pay agreements, reinstated 90-day trials, effective cut to minimum wage against
What are we
official
looking for?
advice. Any of those that have informed you in your current work now, and the results of those cuts, anything that you've used to inform what you're doing now?
They're all very different areas of work that touch on different parts of employment law. For example, the 90-day trials, one area, if you're looking at how it specifically affects the work that I'm doing now, one area would be the 90-day trials policy was brought in under this government as an Act National Coalition item to allow all businesses and all workers access to 90-day trials. It was earlier this year, I believe, where I was alerted to the fact that the 90-day trial system was not working as I had intended under the Act National Coalition, which is why under the Employment Relations Amendment Bill, there is a specific change to the 30-day rule, because I was made aware that 90-day trials were not going to have an effect in all organisations, because if you have a business owner who has a collective agreement in place, all other new employees in that organisation must have the collective agreement for the first 30 days before they can have an individual employment agreement. In many cases, that precludes the ability of the employer to offer a 90-day trial, which is why I am still going for the 90-day trial regime that you've talked about in those first ones, and putting it into the Employment Relations Amendment Bill as an extension of the 90-day trial policy. So to actually answer your question really specifically, that is one area that I'm still working on in relation to those earlier areas.
Okay, I'm going to take a primary from Mike and then a primary from Jan Tinetti. Cool. Oh, sorry. Parmjit, I missed your sup.
That's
Sorry.
all right. Thank you. So this is my
Sorry.
supplement to the primary question about employers versus employees
Mhm.
and the approach that you're taking towards reducing compliance cost and everything else, and a correlation of that to workers' happiness. So, Minister, in your view, is there a correlation here between government being unnecessarily tough on employers and happiness of workers?
Oh, look, I think in some ways you could draw a comparison there. You know, if you have time and resource and money that is being spent on compliance for the sake of it, that's money that's not being spent on an employee. And so by freeing up some of that resource and money that business owners might spend on compliance, that allows more money that could be spent on employees and could, in effect, lead to higher wages or more allowances or other entitlements for an employee. We know that a lot of businesses are cash strapped. So whatever we can do to reduce that compliance burden and cost to business without affecting health and safety, I think is a good thing, because that means there's more resource, time, effort, more money for employees with those business owners.
Thank you.
Thank you. Mike, primary.
Thank you, Chair. Minister, just my questions in relation to the Employment Relations Amendment Bill. In your opening remarks, one of the things you talked about was giving consideration to employees' behaviour and PGs. Have you got any specific examples of personal grievances where employees have engaged in serious misconduct and are granted financial remedies?
I'm sure there'll be many examples of serious misconduct. In many cases, some of this data isn't actually captured by the Employment Relations Authority because when people are taking a personal grievance, many businesses are fearful of the personal grievance process going to the ERA, so they are settling before they even get to the ERA. One of the areas that I know has been quite concerning has been when people do get to the ERA, the data is showing that remedies have been significantly increasing for employees. For example, in the 12 months to the end of November 2023, the average amount of remedies was around $25,000, and the average amount of hurt and humiliation compensation has nearly tripled since 2014. But at the same time, remedy reductions where the employee contributed to the personal grievance had gone down, with the average reduction being around 40% in 2013 and reducing to 22% in 2023. And what this means in part is that this trend means that employees who contribute to the situation that gave rise to the personal grievance are more likely to win a case due to procedural error. And when this happens, they will get higher levels of remedy. But that fear out there in the business community of going to the ERA and having procedural error and rewards given to an employee, even if the employee contributed to the relationship breakdown, is letting people go and settle before they even get to that process.
Yeah, thank you.
Thanks very much. Jan Tinetti.
Thank you. Thanks, Minister. Have you seen any projections on expected workplace accidents and deaths in the next year?
If I look at some of the data that we've received recently from WorkSafe about the projections for deaths and serious injury, I believe we are actually seeing a decrease, and we've been seeing a decrease over the last few years. However, if Sharon would like to come up and talk specifically about any forecasts and numbers, that would be great.
Well, we can just talk about that when we see WorkSafe.
Okay.
I'm just really I don't need the numbers. I just want to know what you've seen, and do you know if these projections have been updated since you signalled the changes to WorkSafe?
I would highly not think that would be the case.
Okay. Do you, as Minister, have a target drop in fatalities and injuries like previous governments?
I do not. But what I hope to see by and large across the system is that we see workplace deaths and injuries continue to decrease. I actually don't think it's helpful to
But you don't have a
specific number of people that we hope would be harmed. I don't think anybody wants anybody to be harmed in any workforce. And so I'm not going to put a specific number and say that number was acceptable because ultimately none of them really should be acceptable. But what we are seeing across the board is a decrease in the rate of harm at work, but it's still too high. And that's why we've asked WorkSafe to focus on those areas where we are seeing deaths and serious injuries occur at a greater proportion than across the New Zealand workforce. For example, in agriculture, in manufacturing, construction, and forgive me for the last one, and forestry, of course. The deaths and serious injuries in those 4 areas is too high. And our aim is that our WorkSafe changes and our changes across the board to focus on critical risk and serious injury will see a reduction in those areas. But I'm not going to put a number on it and say this number was an acceptable number.
Why do you think that having a target makes something acceptable? Surely a target is about targeting that reduction year on year. it's not making it acceptable, surely, but you're making it sound like the moment that you put a target on, you're saying that that's acceptable. And that seems quite wrong to me. It's meaning that you've got this year-on-year decrease in those areas.
Well, what we are seeing is a decrease, but we do believe that the changes made by this government will see a decrease, but I don't want to get into any specific number.
Okay. Any other primary questions?
No specifics anyway.
I've got one.
Oh, yeah.
Jan and then, Tiana, you go first.
Yeah.
Yeah, my question is around the gateway test. Can you like spell it out very clearly, that particular change? I'm talking about the legislative reaction to the Uber case. And in your answer, could you talk about what the gateway, what it was originally, and the changes that you are proposing?
So before I get into the specific change that I'm proposing, I do want to make it clear that this is not an Uber law, as the member has referenced.
Sure.
This is a change to ensure that there is a clearer distinction between employment and contract status. It's not in relation to Uber. There is a gateway test that we're suggesting based on the following criteria, which would clarify a contractor. Someone would be required to have a written agreement with the worker specifying that the person is an independent contractor. The business does not restrict the worker from working for another business, including competitors. The business does not require the worker to be available to work on a specific time of day or days, or for a minimum number of hours, or the worker can subcontract the work. And the business does not terminate the contract if the worker does not accept an additional task or engagement. And so if those factors are met, then the person could still go through the Employment Relations Authority or Employment Court if they'd like to, but they are a contractor by the gateway test. But if one of these factors is not met, then the existing law and the existing test about the real nature of the relationship between parties can still be used in the Employment Relations Authority or Employment Court. And I think this is a benefit to all parties when they're signing up to a contract, because having more people actually have what they are doing and requesting in writing will actually be of a high benefit to workers. And we're seeing more people use new ways of working as we're moving to a more of a gig-based economy. And it's really important that we're getting our laws and settings right for that future workforce.
And what happens if those factors change? Because if you contract for a while, sometimes circumstances change. And if you've signed up for something, but actually the employment relationship the contractual relationship looks more like a relationship between an employer and employee, wouldn't it make sense that should give that worker an opportunity to actually have employee status?
Look,
So what have you got in place in terms of factors changing?
I'm not here to give legal advice, but anybody under this law can take their claim to the Employment Relations Authority. That has not changed. And I would expect in future people will still take claims to the Employment Relations Authority.
Okay, thank you. Minister, we're going to go to Jan Tinetti, primary.
I have two primaries. One is very short, so I think it's kind of a yes or no answer. I just want some guarantee from you, Minister, that a normal length select committee process would happen for the health and safety changes, given that we've had a lot of employment changes that have been rushed through under urgency, and just want assurance that you're looking at a normal select committee process going forward.
My expectation is that the health and safety legislative changes will be going to select committee.
Thank you. I have a question about road cones.
Okay.
Do you have KPIs? Because we talked about targets before. Do you have KPIs for the road cone hotline, given that we know from recent experience, well, not that recent, the last 30 years in the UK, that that hotline was registered 3,400 calls for every road cone moved, and that would be a huge waste of WorkSafe resources if we had the same here in this country. So do you have KPIs and targets for that?
I don't have specific targets. It's a pilot program where we've seen over the first week, we've got 375 notifications had been received. And in our second week, there was 126 notifications received. But I certainly don't have any targets for how many people
So
we
follow
want to
up to
have
that, how many-
notify, because we'd end up with some spam
Okay, sorry,
emails occurring.
Mr. Chair. Follow up to that then, you've had those phone calls. What has that resulted in?
So I'm sure WorkSafe can give you more of a up-to-date analysis
know.
of what is happening because you're having a session with them quite
Yeah.
soon. But I know I have heard of one specific example in Auckland where 30 road cones had been removed from a site in response to a notification. And I think that's really good work. It's showing that it's working. But in part, what is actually supposed to occur during this road cone pilot is that the temporary traffic management plans from NZTA will be rolled out across the country. We know that there are some people who are still confused by having guidance issued by WorkSafe and guidance issued by NZTA, and some of them are still following the old guidance. The overall approach of this road cone pilot is actually to get our inspectors and NZTA inspectors out on the ground, talking to contractors, talking to people on those work sites, to let them know they should be following the new updated temporary traffic management guides, which are far more risk-based, but also so that the road controlling authorities are asking people to implement that new temporary traffic management guide. But when it comes to whether or not I'll have specific targets for how many people are out there calling in, I don't have that, like I say, because we don't want
No, road
bots.
cones moved,
Like
not
actual
people
outcome.
calling in, actual road cones being moved. The target wasn't
see.
around that. Yeah, it's around.
Oh, well, I'm
Yeah.
glad you clarified. Well, no, we don't have targets for that because I think it would be impossible to do that. If you take what I've been talking about, we do actually have a risk-based temporary traffic management system in place through NZTA. In many cases, some people may complain and the worksite will be following those rules. And in some cases, they won't be, but it will be very situation specific and very worksite specific. And so until we know what we're actually dealing with, we can't say that there's going to be an en masse reduction. It's about getting that proportionate reduction.
Thank you, Minister. I think that brings us to the end of our time. Really appreciate the time you've spent with us this morning.